name's Sophia and I'm a paralegal down at Newfields Law, which is based in Cardiff. Currently my role in Newfields is within the EU settlement scheme team. We primarily focus on assisting individuals with applications start to finish and also just raising a general awareness of the scheme because, as some of you may or may not know, the scheme does exist, but some people don't know about it. So that's what we are doing. We're raising public awareness, but also individually advising people who wish to make an application. So just again, an overview there. Newfields Law is funded by the Welsh Government, so all advice that we do offer is free. The application process as well to the EU settlement scheme is free also. So all in all, everything that we do is free of charge. There are a number of other organisations who are funded by both Welsh Government and Home Office, but primarily today I'll be focusing on Newfields' role within the EU settlement scheme. So again, what we do, we raise awareness of the fact that the scheme does exist and is available to all EU, EEA and Swiss nationals and also their family members residing in Wales. Those are people who we are specifically assisting. We support applicants who need to make an application by the relevant deadline, which I will go on to in a minute. We also coordinate with other organisations who may be representing vulnerable individuals, and we work on a client referral basis with a number of organisations within our network. As mentioned, we have a certain OISC level, so we are able to assist with slightly more complex applications. And when I refer to complex applications, usually we tend to assist those who may have criminal convictions, those who hold derivative rights, it's a certain immigration status, but we are also able to help those who are, require some digital assistance and also lack certain documents which may be required to provide for the application to the EU settlement scheme. So an overview there of what I'm going to go through in my presentation today. It is intended to be an overview, but I understand that it is quite content heavy. So the PowerPoint will be circulated after the event. So if you do miss anything, do come up to me at the end of the event, but it will also be all within the PowerPoint. So what I'm going to go through there is what the EU settlement scheme is, relevant dates, statuses that can be received under the schemes, and also potential issues and pitfalls of the scheme. So what is the EU settlement scheme? So the EU settlement scheme is designed to provide EU citizens with a status post-Brexit. Following the end of free movement, this will be an immigration status that EU citizens and their family members may use to continue accessing all the same rights and benefits that they are at the moment. The scheme is entirely digital. It requires a two-stage process. The first part, an ID check, and the second part, a residency check, in order to enable the individual to gain the correct status. So who can apply to the scheme? All EU, EEA and Swiss nationals are able to apply to the scheme, as well as their family members. They must be living in the UK by the, sorry, that's a slightly incorrect date there. So they should have been living in the UK by, sorry, that is the correct date. Right, so they should be living in the UK by the 31st of December 2020, so the end of the transition period. Irish nationals do not have to apply, but if they have a non-EU family member, they can use that application so that their non-EU family member may also apply. So key dates and deadlines. As we know, Brexit date has already been the 31st of January 2020. So in relation to the settlement scheme, applicants must be living in the UK by the 31st of December 2020. That is the correct date. And they must make an application to the EU settlement scheme by the 30th of June 2021. So we've got about a year and a couple of months before the scheme is no longer available to people. It's not known yet what will happen to those who haven't applied to the scheme by that date. The government has given no advice as to this. The Home Office has given no advice as to this. So it's strongly urged that people do submit that application by that date. So the two different types of statuses that you can be granted under the scheme are settled and pre-settled status. Settled status is otherwise known as indefinite leave to remain, and pre-settled status is otherwise known as limited leave to remain. So the difference between the two statuses: settled status you can obtain if you have been living in the UK for 5 years or more. Pre-settled status, less than 5 years. So this 5-year period must have been a 5-year continuous residence. And what we mean by that is that there were no absences exceeding 6 months in any 12-month period. This any 12-month qualifying period does not relate to a calendar year, it is any 12-month period. So individuals have to make sure that they are applying to the right status and understand that absences may have affected on what they are able to obtain at the moment. Both statuses will enable you to continue to work, study, access the NHS, social security, certain benefits. The two main differences between the statuses is that with the settled status, you are granted more flexibility in terms of your absence from the UK after obtaining the status. So with the settled status, once you have been granted that, once you've obtained that, you're able to leave the UK for up to 5 years without losing your settled status. Every time you come back into the UK, your clock would restart, so you would be able to have another 5 years, and so on. With the pre-settled status, you're only able to have absences of 2 years once obtaining the status without losing the pre-settled status. Individuals will eventually need to upgrade to settled status. So those who are currently holding pre-settled status, have been living in the UK for less than 5 years, will need to submit an application for settled status 5 years from the grant of their pre-settled status. So those with the pre-settled status, it's very important for these people to keep track of their absences and to make note of when they are able to upgrade to the settled status. The process. So as mentioned before, it's entirely digital, which for some people is great, for some people is not. The scheme is intended to be quite user-friendly, but I myself have struggled with it, so there are certain difficulties to it. It takes part in a 2-step process. The first is evidencing your identity, and the second, your residency. The first part is done typically by using an app on either an Android or an iPhone. And this is where the individual will scan their passport or national ID card using the app. The app works by reading the biometric chip within the identity document. The individual will then be asked to input some contact details and to make sure all the information gathered by the app is correct. There are other methods to proving your identity if you don't have a biometric document or you do not have access to the app. There are document scanning locations dotted around Wales. I believe there's more and more coming up. And there are also organisations like my own that are able to assist people who are struggling with that part of the app. The second part is about evidencing your residency. So this will typically be done to establish whether you are able to gain the pre-settled status or the settled status. This will be typically done by inserting your national insurance number, which generates an automated check, gathering records from both the HMRC and DWP, and this will hopefully establish how long you have been in the UK. Typically, we have found that people have found gaps in these records that are generated by the automated checks, so they may not always be granted the correct status. The onus then falls on the individual to upload alternative documents to evidence those gaps and enable them to obtain the right status. I'll go slightly into that in a later slide. Proving your status after it is granted, again, will be a digital process. It will be done through an online link. You will have an online profile which you will be able to share with third parties, and you will also be able to access yourself. The scheme has no cost, and the advice that my organisation provides is also free of charge. Initially, in the pilot, there was a fee of, I think it was £80. So anyone who has applied to the scheme and did pay for it is entitled to a refund.
Can I just ask a question?
Yes, yeah, of course.
Can you just go back?
Yeah, of course.
Sorry.
Yeah.
Why do you have to prove status after it's been granted?
Sorry, so that's meaning if you were required by a third party to show your status, to show that you have either the indefinite leave to remain or the limited leave to remain, there is a separate website for them. You will be required to share a code to that third party, be it an employer, landlord, and they will be able to input that code into their own portal almost, and they'll be able to view whether you have the status or not. As it stands at the moment, people are not supposed to discriminate individuals as to whether they have applied to the scheme or have not until the end of the transition period as well. So on this slide, I've included some links to some further guidance documents. Upon the Newfields website, and specifically the EUSS page of our website, we have embedded a link to a walkthrough video of the scheme for both adults applying and children applying. These are really useful for if somebody wants to gain an overview of what they're sort of going to be expected to answer and what documents they may be expected to provide. And it is a walkthrough of the actual application process. So I myself found it very useful when I was preparing to advise individuals and preparing to go through applications with them. There's also a link there to a Home Office document. It's intended for caseworkers, but it is a very thorough guidance document, and then there is also the Newfields Law website there. So those with permanent residence in the UK are still required to make an application to the EU settlement scheme. It will be a slightly quicker process for them, as they won't have to provide any further evidence of qualifying residence, but they will still be subject to the certain criminality and suitability checks that everybody is subject to. The Home Office will need to confirm that their permanent resident status has not lapsed as a result of being absent for more than 5 consecutive years.
Sorry.
Yeah, no, that's fine.
How do you define permanent residence? I mean, if somebody's lived for donkey years in the country,
Mm-hmm.
they're permanently resident, but do they still have to go through EU SS if they're Spanish? Or?
They would. So the only people who are exempt from the scheme are Irish nationals and also those holding indefinite leave to remain. However, I'm going to go into a slide on indefinite leave to remain, and we do advise people with that current immigration status to also make an application through the EU settlement scheme. So unfortunately, yes, even those who have officially applied for a permanent residence card document, although the word permanent residence is slightly misleading here, so they will also need to be making an application. This is where there's some confusion, because people may have been born in Wales, in the UK, never have left, but are still EU nationals. So in their mind, they don't believe that they need to make an application, but in fact they do. So those with indefinite leave to remain and indefinite leave to enter, it's not strictly necessary for these people to apply to the settlement scheme, but it is advisable to avoid certain hostile environments and to avoid undergoing time-consuming checks at any borders. It's also worth noting that under the old scheme of indefinite leave to remain, this one that I'm mentioning here on the PowerPoint slide now, the max absence for those with indefinite leave to remain or indefinite leave to enter under the old route is 2 years, whereas under this new scheme, they have an absence maximum of 5 years. So in that respect, there is greater flexibility in this new scheme. So under 21s, it's typically thought that under 21s will not have to make a scheme, that if their parents are making an application, they will automatically be granted that status. That is incorrect. So under 21s must make an application of their own right as well. Of course, their family member, parent may assist them with this, but they do need to make their own application. Under 21s may apply based upon either their own eligibility or their parents' eligibility. So this depends on how long either parent or child has been in the UK for. It may be that the child is 3 years old, but the parent has been here for more than 5 years and so is therefore entitled to settled status. Of course, the child cannot accumulate a 5-year continuous residency because they're 3 years old, but by linking their application to their parents, they are able to obtain the same status as their parent. On the other hand, they may also apply on their own eligibility. If the under 21 has been in the UK for longer than their EU parent or family member, they may also apply on their own right, on their own residency. So non-EU family members are categorised into two different classes. So it is close family members and extended family members. A full list of these can be found online in the guidance, but typically close family members will cover spouse, civil partners, children under 21, and extended family members can go as far as covering brothers, sisters, aunts, uncles, durable partners. So again, non-EU family members who wish to make an application to the EU settlement scheme must be living in the UK by the end of this year, the 31st of December 2020. If they are currently outside of the UK, they may enter the UK on something called an EUSS family permit. This enables them to come to the UK for 6 months, and in that 6-month period, they may apply to the EU settlement scheme and obtain a status under that. Family members are advised to apply after the EU sponsor, as they can then link their applications to one another. So how non-EU family members apply? Family members will also have to follow the same basic application process as their EU sponsor, but the family member will be asked for their own identity, residence, as well as their sponsor's identity and residence. And then they will also be asked to evidence their relationship to the sponsor. So this may be a marriage certificate or a birth certificate. An existing permanent residence card will count as proof of all of the above. So again, it's a slightly quicker method of getting through the scheme. So other citizens who are also eligible to apply to the EUSS are non-EU spouses who may have recently divorced their EU partner, can also apply to the scheme if certain criteria are met. Also, non-EU spouses whose EU partner has recently died are eligible to apply, providing, again, certain criteria are met. And also non-EU carers of either British or EU children can apply. These carers will have to apply for a paper form. It is a slightly different application process for them, and it's slightly more burdensome as well. There is more evidential requirement there. Non-EU carers will be listed under either Chen, Teixeira, or Zambrano. They will typically know that they are this type of carer, and they will have to phone the EU Resolution Centre to acquire a paper form to be able to apply to the scheme. So the potential issues, you may have figured a couple of these out already from the previous information. So there are certain barriers to applying. IT technology is not for everybody, so many people find it difficult to apply to a so-called user-friendly scheme because of these issues. There's also issues where people lack certain ID documents or residency documents. You'd be surprised at the number of people who have lost their ID documents, their passports, national ID cards. It's not uncommon at all. So at Newfields, we are able to assist with obtaining these again, and we are also able to advise on what residency documents, the alternative evidence to fill in gaps from the national insurance record automated check. We are able to advise on what documents would need to be provided for this. Another barrier is just not knowing that they need to apply. So every EU citizen has to apply if they do not also hold a British passport or indefinite leave to remain. That is the basic of it, really.
But they should have a document saying indefinitely.
Yes, they'll either have, if it's quite an old indefinite leave to remain application, it may be a stamp and a passport. But the new way of applying to a definite leave to remain, they may have a physical document, such as a biometric residence permit or something like that. So those individuals are not required to apply, but again, as I mentioned, it is advisable to have a status under this new profile, under this new scheme. So there are also issues where people have incomplete national insurance records. This is very common, and it is not through any fault of the individual. It may be down to retirement, changing of jobs, self-employment, or gaps in employment. So in order to evidence these gaps, you are required to upload additional residency documents. people have sometimes found this hard. You must upload the document and then assign dates to the document done through the online profile. Many people have also been granted pre-settled status when they are in fact eligible for settled status. So please, if you have anyone who is eligible for settled status, offer the pre-settled status. Do not accept this. Tell them to not accept that. They may reapply through the scheme, uploading further documents to show that they are in fact eligible for the settled status, but you should be going for the correct status that you are entitled to. If you're awarded the incorrect status while the scheme remains open, do reapply because it is free of charge. As of the 31st of January 2020, applications made on or after this date can be appealed. Newfields do not assist with this, but we are aware of the fact that you may appeal, so we can advise you as to any next steps on this. There's also something called administrative review. The process costs £80, and it is for individuals who don't believe they have any new evidence that they could upload to an application. So you must submit this no later than 28 days after the date on your decision, and you will not receive the money back unless you are successful in your case. Ultimately, we do advise people to just reapply. The scheme is free, and you are able to make as many applications as you like. So the position for EU citizens entering the UK after January 2021 is still unknown, but it's expected to be some form of skills-based immigration system. This is going to be a far harsher and stringent system to get into. And so whilst it is open, advise people that if they do wish to remain in the UK or they do wish to come to the UK to apply under the EU settlement scheme. So this scheme will be open for EU citizens who are entering the UK after the 1st of January 2021. So again, going back to what Newfields does, within our public awareness campaign, we typically involve ourselves in activities such as having stands in local places, so stands in civic centres, libraries, hospitals, any public spaces where we may just gain awareness of the scheme and give people a bit more information. We have also attended a lot of community cohesion events. We've attended a lot in Cardiff, but we are also trying to branch out. We are covering the whole of Wales, and we're getting there slowly but surely, but sometimes some places are slightly more hard to reach than others. We are working with Welsh Local Government Association. We are working with employers to gain an awareness that their staff may need to apply. We are working with vulnerable persons groups, and we are also offering stakeholder training. So this is typically for frontline staff who may be able to drip through the information to people who are required to apply. The more specific individualized immigration advice service that we offer is advice on the whole process, really. So we advise on eligibility for either settled or pre-settled status. We are able to assist people in reviewing the supporting documents that they may wish to upload. We are able to give advice on applications in person, over the phone, email, web chat, at the various events that we are going to. We're there to help. We're able to assist with any post-application queries, including questions raised by the Home Office. We are also able to challenge decisions by reapplying or people who may wish to carry out an administrative review. We support other service providers within the EU Citizens Immigration Advice Service through our client referral system, and we also advise relevant third parties as to how the EU settlement scheme may affect them. So I know that seems like a lot, but I will welcome any questions at the end. But there are contact details up there. So the info at Newfields Law is specifically for the EU settlement scheme. Myself and my colleague Abby are sat at the end of that. And there are also 2 phone numbers there. The second one is my direct phone number. The EUSSWales.com site that you can see there is for all organisations within our network, within our client referral network. So whilst Newfields is there to support more complex cases, there are also other organisations such as Mind, CAB, TGP, who may focus on more specific individuals, more specific areas of people. So on that site, you can see an overview of what each organisation does and who they are more adept at assisting. Also, there is the newfieldslaw.com/EUSS page, which contains frequently asked questions. So it's sort of an overview to what troubles you may encounter.